Okay. For the university constitution is the highest document for the university, right? How about the federal constitution? We all know there is a federal constitution. So, federal constitution, Parliament Act, the Contract Act, Criminal Act, Employment Act, then state constitution. Who know the difference? Okay, federal constitution is a perlembagaan persekutuan. Federal constitution is the supreme law of the country. Okay, Parliament Act, like the Statutes, Contract Act, Criminal Act. So those are the acts are created by Parliament. If any conflicts between Parliament Act and Federal Constitution mainly about fundamental rights. Any conflict, Federal Constitution will prevail. Okay, each state has their own constitution. Selangor Constitution, Kedah Constitution. So Selangor Constitution cannot enforce in Kedah, so it's only applicable in Selangor. Any conflicts between state constitution and Parliament Act, which one prevail? Parliament Act is prevail. Okay, it's just an additional knowledge. Okay, now I'm going to give you activity. I have created four agreements. Okay, 1 MOU and 3 agreement. Okay, so many mistakes in the agreement. Full of mistakes. I want you all to identify the mistakes. Okay, it's the common mistake what usually people will do. Identify and then write it on the paper given. Then we will discuss. So it's a group discussion. Okay. So based on the morning session, so use that knowledge and then identify the mistakes. But not all is mistake. Certain is right also. Certain clauses are correct.
So it should be LOI lah. is laws of Malaysia. Laws of Malaysia. Malaysia. So Malaysia. Follows Malaysia. Number 5 is an NBS. Yes.
celebration and you also. Okay. Okay. Which group want to go first? Then another group can count this. Okay. Okay, can we start? Okay. So, Lori and Yusra are going to spot the mistakes. Okay.
Okay, good afternoon, everyone. So I think after going through the document, we felt that it's not an agreement, it's probably more of an LOI, because a lot of things are not, or if it wants to be an agreement, you need to be more specifics in like purpose, project scope, and everything. Okay, so the first thing is there's a missing date there. And I don't know whether we can divide, and it's probably just between UCSI and Innovate Tech. Yeah. So there's a missing date. No need to buy, just between. Missing registration number for Innovate Tech. So there's a missing registration number, right? And I think when we describe the company, there's no need for the purpose, for the purpose of collaborating on technological research. I suppose that should fall under purpose rather than under the company details. Yeah. So that's yeah. The purpose should fall under company detail. Project scope, if you read through, they're still discussing milestones, deliverables. So we felt that the project scope is unclear between party A and party B, and even the financial contributions are also a bit vague, like party B reserves the right to collect without and not obliged to disclose with party A. So or it's a bit one-sided. One-sided, unclear, vague, so including the IP as well. The IP also is a bit unresolved. I mean, you don't know who owns the rights, where you can, although it's jointly owned, but you can use it at any time. I'm not sure, but we felt that it was not clear as well with the IP. Governing law at the moment, because the two companies are one in Malaysia, one in Singapore. So the governing law is with the laws of Singapore. Perhaps it's best to have both governing law, the Malaysian and the Singaporean governing law. Yeah. And The witness is, so she should be the person who signs. Yeah, so it's the balik, yeah, the witness and the secretary. Yeah, so I think that's all. Yeah, but pretty much the whole thing. Yeah.
Thanks, Ms. Daria. Okay, both of them did the same collaboration agreement. So let's see.
Alright, thank you. So for this one, it's the same document. So I will not repeat myself. So what we also saw that it's lopsided, meaning that one side is at the advantage and another one at the disadvantage, because we see it like financial responsibilities and other things there. Also disputes that there was 2 members from one side, 3 members from another side, so it's unequal in this sense. So here the termination also no specific time. And for things that were omitted, for example, there is no warranties and representation there. Also indemnification, no assignment, no first partial clause, and also no licensed people listed there. So that's important things that were missed out here. Okay, that's it.
Okay, great job. Okay, let me move on.
Okay.
No, no.
Is it normal to look at this speech is intentionally left back?
Yeah. Just give me 5 minutes, I want to explain. Okay. No one spotted the mistake.
This one up there.
Okay, good. So, supposed to be Ministry of Higher Education. Good job. Okay. Okay, see the project scope. See, when we enter into an agreement, the terms must be definite, confirmed. We cannot say still in discussion, future discussion, no specific commitment. Those are the words we trade with. We cannot use those kind of words to be determined at later date. So then what's the point we are signing? To be determined at later date, maybe you can mention that LOI, because that's the purpose of LOI. Okay, like what the other group say, like mostly, for suit for LOI. Okay. Party B reserve is one-sided. Right to collect fund from third parties for this project and not obliged to disclose the amount to party A. So it's like more to one-sided. And IP also, party A reserves the right to use the IP without informing party B at any time. the important other terms are missing. So it's good to include. Okay, good. So next, student exchange. Okay. Student exchange.
So they discovered the things that we have to do.
Okay, hi. So, I believe in UCSI we have
Hi.
So my name is Rick and it's my friend Sophia. Okay, yeah, okay. I believe in UCSI we have two type of module. One is for ACA and one is for survey. Yeah. So and for this one, I think for the student exchange agreement is under SLA. So basically, the flow my team earlier got from this MOU is number one is agreement without date. The agreement is without date, no specific date mentioned here in the agreement. And then number two is the company name should be used is the UCSI Education Sdn Bhd instead of MBM, Company of Business Management. And then I also didn't mention about the registered number, the registered company registration number. Yeah. And then number three is again, no specific duration was stated for earlier return. Number three. That's right. It's under two terms of exchange. Yeah. It's just mentioned student may, however, return earlier and return regardless of the progress. Okay. And then number four, the financial responsibility. Yeah, the financial responsibility is not clear. Doesn't state what kind of it's either the post or home institution need to bear the financial in case whatever happen. Okay, and then number five is the law. Governing law and dispute resolution. It mentioned here is the law of Hong Kong. Law of Hong Kong. Okay. Yeah, it mentioned here the law of Hong Kong. And then the court of China shall have exclusive jurisdiction over the dispute arising from or in relation with this agreement. So there is yeah.
One party is the Malaysia.
Yeah, the other one is China.
And suddenly Hong Kong law is there.
Yeah, suddenly Hong Kong law is there. So it's like question mark here. Okay. And then the positionality is not clear. Yeah. Okay, next one is we move to the duration. Yeah. Number 7. The duration should be stated clearly, which in here it just mentioned about the agreement shall remain effect for an infinite period starting from the date of signing. Either decision may review and purpose renewal as necessary. Not detailed. Doesn't show the duration. And then number 8 is the termination. Okay, termination of notification. So should be either decision may terminate this agreement at the time with immediate written notice should be prior to notification. Yeah, and for example, like 1 month from both parties. Okay, and then number 9, the language clause. We did mention about language. This agreement is prepared in both English and Chinese. In the event of dispute and inconsistency, the Chinese version shall prevail. So there's no Chinese version here. Okay, and the last one is the signatory. Again, they put the faculty here, should be the company name, the UCSI Relations in Berhad, and then the witness should be the DVC. Yeah, this one is state program, and also of course they are using the same people, because the witness must be from the both party. One is from the UCSI, for example, the other one is from this company. Okay, so yeah, that's all. Thank you.
What is having student exchange program?
So we totally agree with the previous team, and we thought that we would need talk anymore. But then we have some points that we would like to highlight as well. I think the first thing would be instead of agreement, it should be a letter of intent. And the second part would be at the Global University, that part, the registration number is also missing. And also for the purpose, because they say that it will be determined at a later date, but actually some of the details has already been detailed out in the clause, second clause, which is terms of exchange, which at least they already started after something, so it shouldn't be at a later date. And the last part would be at the end, for confidentiality, we think that NDA should be attached as well. And last thing would be page number is missing for every page, so I think we should add a page number.
Okay. So everyone correctly spotted. So after this, no more I'm receiving. Okay. Frequently I am receiving. Sandara. Okay. Very frequent. So I have to do all this. Okay. So after this, I hope UCSI education, okay? And then okay, purpose will be determined at later date is wrong because agreement must be definite terms, okay? And terms of exchange of students. So students are automatically admitted is wrong. So they must fulfill certain criteria, right? Okay. And also, see when go there, they must know how much they should pay. You know, it cannot come as a surprise. Also, any additional fees for the traveling accommodation, health insurance also specified. Otherwise, personal expenses also, you know, specified otherwise is also wrong. Governing law is Hong Kong. Hong Kong is not a party to this agreement. One is from China, another one is Malaysian University. So it must be both countries' law. And also courts of China shall have exclusive jurisdiction also, not appropriate. So we can choose where the dispute occur, that country can be the jurisdiction, right? So that court can have a jurisdiction where the dispute occur. Okay, now duration is indefinite period means no end. Okay, no end. So we cannot do that. And termination is with immediate. So if immediately terminate, then what will happen to the student? See, no longer responsible. The host institution is no longer responsible, and all the academic activities cease immediately. Also unfair to the student. Okay, language, Chinese version shall prevail. Okay, so it's supposed to be English version prevail. Oh, okay, okay, the witness. Okay, this one correctly identified. It's a UCS education. Okay, witness cannot be, Dr. Benedict cannot be witness for both institution. Okay, he only can be a witness for the UCSR University, but here in UCSR practice, Deputy VC will be the witness. So the other side for the global university, young people must witness. I just want to identify the mistakes in the agreement. Okay. You want 29 hours. Finish it, and then it was early. Okay, next group. Research agreement. Research agreement.
So the first obvious one is the date is the same. While the name of UCSI Education Sdn Bhd is correct, the company number 0 is missing. So the company number is also correct. It's 0185479 or something. Oh, so maybe remove. Okay. So Tech Research Solutions Sdn Bhd does not exist based on CITOS. Neither the company name. We tried all over, we cannot find it. So therefore, we cannot verify that the address is correct. So that's the issue. I think the purpose is okay. There's not much issues there. Scope 2.1 is okay. 2.2 it says something about. I want to draw your attention to final But 2.3 is a big issue. The company, which is the other party, shall have full discretion to adjust. So it is very extremely looks like that. Actually, the whole thing I felt like carrying it, to be honest. Next, financial obligation, remember, is on the other side, right? Party B. So you see here, the company may provide funding at its sole discretion. So earlier they said the funding part is at the company, but now it says is their discretion. So I think it doesn't carry there. And the next line, in the event that additional funds beyond the budgeted amount are required, UCSI is to ensure the completion of the research using its own resources and funding. So this goes against the earlier clause that says funding is on party B, which is the company. And then intellectual property, this is a research agreement, so it should benefit both, but in 4.1 you see solely, belongs solely and exclusively to the company, so I don't even know why UCSI wants to sign this. And then 4.2, without any obligation to share profits or royalty with UCSI University. Again, question 5, confidentiality 5.2. So these obligations shall survive the termination of this agreement indefinitely. That is also an issue there. Publications, okay. So normally we do research for publications. So 6.1, it says all publications and all communications regarding the project funding shall be under the sole authority of the company, which is Project B. So you see, it doesn't get anything unpublished. And then in the next one, it says company's explicit prior written consent. So UCSI cannot publish anything without the consent of the other party. So again, we decided. The biggest issue here I thought was in number 7. No specific timelines, milestones, or deliverables are defined by the parties. So nothing. So I don't know what to say about this. 7.2, the company, which is party B, extends, modify, or terminate the project at its sole discretion. Again, this is against, it doesn't benefit UCSI without providing any justification or bearing any liabilities. Question number 7.3, also a big issue. UCSI University shall bear all costs incurred up to the date of termination. So earlier clause was saying financial obligation is on the company. Now it's pushing back to UCSI. And then it says also regardless of any changes to the project scope or timeline made by the company. Again, not fair to UCSI. Disputes. So disputes shall, second line. Mediation may be pursued by the request and expense of UCSI University. Again, looks like that. Governing law, I thought this was the only thing okay because both companies appears to be from Malaysia, although second company does not exist. Termination. 10.1 second line, whereas UCSI University shall not have any right to terminate this agreement. So that's a problem there. 10.2, UCSI University shall immediately return all research material, equipment and data to the company. I don't know how this will benefit UCSI. Last but not least, no penalties or further obligations shall be imposed on the company upon termination. This is not like bias, but this is better you don't have the agreement at all. Last but not least, so here there's no signatures, no signatories, nobody has signed. Director and Vice Chancellor, I think is not equivalent. Usually it should be of the same level, I believe, correct? Oh, okay, so it's equivalent with the Vice Chancellor? Okay, I didn't know that. Second one, anybody can sign according to David, but this head of department, I assume is from this company, and she is from UCSI, so I think there's no issue. Correct? Okay.
No one to add because we have the same agreement. They never did it.
Okay. Research agreement. Okay, let us see. For this research agreement, right? Who is the first party? Okay, I scroll down to the signatory page. Yeah. So common problem I'm facing also. Okay, common problem. So you all must make sure first party here. Second party here. Okay? Because all these are very fundamental. Okay, let us see. Okay, like no, I did it. I actually all the name even I use my daughter name also as a head of department now in here. Okay, so the 2.3. See the full discretion to adjust the project scope, timeline, and objective as is deemed necessary. So that's not a fair clause. Okay, financial contribution, stamping fee 3.2. They want UCSI to bear the stamping fee, and 3.1 provide funding at their sole discretion. They can decide how much they can give. If any additional expenses, they want UCSI to bear it. Okay. IP, yes, the company want it solely, exclusively, they want it to belong to IP. And company, they retain the right for the IP without any obligation to share profit or royalty with UCSI. Okay. For the publication, company retain sole authority, and see UCSI can write to the company for the concern. If you notice the second line, the company reserves the right to withhold such concern. It's totally unfair. Okay, project timeline. Actually, 7.1 to 7.4 all are one-sided. Okay, one-sided. See, all are favor to company. Okay, and then the dispute resolution also they want UCSI to spend. Okay, termination is at any time. They can terminate any time. We cannot terminate. So always must be a mutual. Okay, both parties can terminate the agreement. And no penalty if the company terminate the agreement. Okay? And the last page I already explained. So it's supposed to be first party, usage allegation supposed to be here. Second party is supposed to be here. Okay, last one is MOU.
Good question, everybody. Good. Yeah. Okay.
they will use sometimes only UCSI or UCSI education or UCSI university. So I need to, from top to bottom, I need to correct it. Okay? And see, this one also the responsibility of UCSI education supposed to be UCSI university. So the consistency is very important for the agreement. And here in after known as UCSI university means we must practice as a UCSI university. Except the signatory page, we must back to the company name, UCSI education. Okay, financial term has not been decided for future negotiation also wrong. And see this MOU for the purpose of scholarship, right? So the company want to give a scholarship. If MOU is not binding nature means the company is not obliged to give the scholarship. So either you sign agreement with the company or you make it as a binding nature. Okay? Because they want to give a scholarship, right? Okay, termination. Usually after termination, we must think if there is an ongoing project, what will happen to the project? Or if any student is under their scholarship, what will happen to the student? So we must say something. Okay, after termination, the ongoing project will be completed within 3 months period. Or for the student, for this case, the student who already under the scholarship will not be affected by this termination. Those are the things we must mention. Otherwise, it's redundant. Okay. Okay, governing law, both are Malaysian companies, so Singapore law is not appropriate. And this will be my common problem as well. Always leave empty. Or they will ask me who should be the liaison person. So they and also sometimes they just put UCSI and phone number. Okay, supposed to be the person who project owner or the person whoever from the faculty knows about this project. Okay, and here supposed to be UCSI, University Sedia Berhad, and witness Dato' Rohana. Okay, Deputy DC. Okay, so far so good. We can add. So we can add. Okay. UCSI, we practice to use our template. Okay, because we are more comfortable. But no wrong we use other people's template. We can amend it provided they agree to the amendment. Then they can do the translation. Okay, and then another thing, if you receive PDF format agreement, you must ask them to give word copy because you can only amend using the word copy. PDF project owner will do. Don't know whether they don't want to ask, or they will, if they ask, the company will think something. They themselves will convert it to word. That's legally wrong. Cannot. They should have the word copy. They should give you.
You are the first party, we will not do what the or for example, the company is the first party. Means what they do or we
Not necessary. You can check with them. You can tell them we already have the MOU template. If they're willing to use ours, then we can share ours with them. Or if they want, if they want me to use their template, also okay. No, not necessary. It is not make any difference. First party, second party. First party means like who initiate first. Yeah. It's binding because it's signed, but only thing when the effective date, if there is a duration for 2 years, so when then only we know, okay, when the 2 years will finish. Yeah. You mean the first page or second? Oh, that not necessary. Important is the date of the agreement, not when we sign. And then, do you have a question?
The impact of impact.
Can we take one